2 weeks adjournment may be given as the leading counsel is out of station. Prayer is allowed. List the matter after 2 weeks.
My lord, if I may mention other items
Yeah.
by the same council. Item 4, 6, 7 and 8.
Of the daily list
Hearing list, my lord.
of the here.
My lord, in item number 8, I'm objecting to the
Okay. For 4,
4, 6, 7 and 8.
4, 6, 7, and 8. Anyone from the other side in these
My lord.
matters? You're there.
I'm appearing for respondent number 2 in item number 4.
Item number 4. Okay. He's out of station,
My lord.
so I think this can be accommodated. You are in which, sir?
I'm in item number 8. Number 8, my lord.
8 RFA.
For respondent number 1.
Okay. Then you walk out a short date. When is he coming back?
My lord, after a week.
After a week?
My lord, can it be fixed next week?
It can be.
Yes, because if he doesn't come back, they can pray.
Okay. 4,
6, 7
6, and 7.
and 8, my lord.
4, 6, and 7. On the prayer of the Learned Council. Adjourn for 2 weeks. Will it be okay?
My lord, 1 week for item 8.
Yes. 4, 6, and 7 for item 8. Full stop. You are Mr. Learned
CL Fakzola.
Yes. Mr. Council, Learned Council for the respond. You are for all the
Respondent
respondents?
number 1.
Respondent number 1 submits that the matter has been pending and seeks an early adjudication. List the matter. You want a date in the next week? Specific date? If you want a specific date, it can be fixed. Otherwise, we say after a week.
Can we attempt at 5? 5th March? 5th March?
5th March. 5th March, you. Because, let us say after a week.
My lord.
Or 4th.
4 is holiday, my lord.
Also, 4 is holiday, right? Because 5th, I'll be leaving because I have a training in Bhopal.
My lord,
Right.
my lord.
So that is why, because if the hearing takes time, that it may be. Otherwise, you get it fixed on Monday.
Monday?
2 weeks
Yes,
after.
ma'am.
Next, just this Monday. Not this Monday.
2nd March?
2nd March, yes. No. Not the week after that.
No.
The week after that.
Okay. As
That
per
will
your
be-
lordship convenience.
That will be 9th March. Is
9th.
it okay?
My lord.
Okay.
Is it okay?
Yes,
Okay.
my lord.
9th March is okay.
Obliged.
My lord, item number 9 of hearing list, my lord. Item number 9.
Yes.
This may be taken up on this Thursday.
This Thursday. Thursday.
My lord, I would like to make a mention on part 2, item number 2, like if the matter could be listed after a week.
Okay.
I have taken the consent of the other
Okay,
council.
after a week.
Okay. Obliged.
My lord, item 10 of part 2. It's a jail appeal. I'm the amicus. This can come up after a week, my lord.
After a week.
Yes.
Do it.
Part 2, item 10.
Try to do it on the next day. It's a jail appeal.
My lord,
on the
yes,
next day.
yes.
After a week.
Obliged.
Daily list.
Motion, item 1.
Yes.
My lord, by filing the present writ petition, I'm seeking an appropriate order against the settlements officer of Champai district, my lord. Here, my lord, the case is that initially an application was submitted by the
Yes.
petitioner's husband to the settlement officer Champai for inheritance of a particular plot of land.
Yes. I had
There
gone
is a-
through a bit of it. I had gone through a bit of it. So it was, and you are only seeking a direction to
direction.
consider your settlement.
Yes,
right?
yes, my lord.
It may be possible to dispose it off without full hearing, but
Yes, yes.
let us see. You for the, ma'am, you for the, are you appearing for the state? Because I think this order was there's a previous order or something. No, you have filed an additional affidavit also, sir?
Yes, my lord. I have already filed.
Okay, clear. Yes, ma'am.
I'm appearing on behalf of the state respondents.
State respondents. Okay. Have you received copies of the writ petition? Yes, you have? So either you can file a pleading or take instructions, maybe, because the prayer is, it's just they want a direction for heard and counsel. You are appearing for respond number?
1 to 3.
Actually, your names have not shown up. No? First. 1, 2, and 3. First. You furnish. You received the copies. You say.
Yes, madam.
Yes. Earned Government Advocate appears on behalf of respond number 1, 2, and 3. First. 4 and 5 are private respondents.
My lord.
Okay. You have to issue notice then, right?
Yes.
So that will necessitate a notice.
My lord.
Okay. So steps of notice shall be taken upon the respond number 4 and 5, who are private respondents. Full stop. The writ petitioner in this writ petition is seeking a direction for settlement order over the land covered by permit number 20 of 1963, located at Jamadar Bank, Champai, right?
Correct, my lord.
Champai district of Mizoram. Full stop. Prayer portion. Then we have to go through this process. You have to just file a, take steps. And the petitioner has also filed an additional affidavit. The state respondents are at liberty to file an affidavit, if so advised. You can take instructions and put it down in an affidavit. Yes, then we can, at the admission stage, we can perhaps dispose it of. So no need to admit it and post it for hearing. Oh, it's for motion. List the matter after so and so in the admission column. After you take steps, it can come in the admission column. Extra copies may be furnished if necessary. Right?
Yes, my lord.
After since you will be taking steps by registered post, speed post. You take by speed post. Steps by speed post. And list after 4 weeks or 3 weeks?
3 weeks, my lord.
3 weeks.
Item 2.
May it please, Your Lordship.
Yes.
My Lordships, here, my Lords, we're impugning two orders of one particular order of the settlement officer, and my Lords, we're seeking the compensation which was awarded under the National Highways Act to be released to us, my Lords.
Okay. Compensation was also already finalized?
Finalized, my Lords. The award was
not paid?
Not paid. My Lords, what the respondents had done was, they had undertaken some separate proceedings. Under what provision of law, we don't know, my Lords.
And
stating that, yes,
okay, that the land is not coming.
Not coming,
and
my Lords,
subsequently.
yes.
Right. Yes. Anyway, necessitated. Ma'am, you are appearing for this?
I am appearing for respondent number 6. Lordship, I am appearing on behalf of respondents number 1 to 3 and 5.
Learned counsel appears on behalf of respondent number 1, 2, and 3, and respondent number 5.
5.
Madam, you are appearing for the Highways Corporation,
Yes, my lord.
Union of India. Respond number?
Union of India.
Respond number?
6.
Number 6.
Respond number 6. What about 7 and 8? 7, 8. 7 to 9, respond number. Appearing for this, 6, ma'am. And 4, additional Deputy Commissioner, Kala.
We'll have to take steps.
Okay. You are not representing. You cannot represent, Kala. You cannot. Is there any standing counsel for this? No. Government advocate. You have to take steps.
My Lords, for respondents 4, 9 and 10, my Lords, I'll take steps. So 9 and 10 are 10 and 11.
10 the private respondents.
Yes, ma'am.
The petitioner shall take steps upon respond number 4, 9, 10 and 11. 10 and 11. 4 you can take by dusty also, I think.
My Lords, we
The
can.
authority located here.
Yes, ma'am.
The petitioner is also at liberty to take steps by dusty as well. Stop. You have received copies, ma'am? No.
Yes, my lord.
Yes. Extra copies may be furnished if necessary. Full stop. You take the instructions and put it down in a counter, and then we can. This
Yes,
also probably we can decide at the stage of admission.
Yes, ma'am.
Full stop. This is the matter after 3
4
weeks.
weeks.
4
4
weeks.
weeks, my lords.
In the admission column.
Yes,
Let it be in the admission column. Okay.
Obliged, my lords.
Admission, item 3.
Your Lordship, as per the office note dated 23rd February, service report from none of the respondent has returned till date.
Has been received.
He has not been returned till date.
Heard. So for the appellant, insurance company, you are agreed by the quantum.
Yes, my lord, Contempt.
Agreed by insurance appellant's company against judgment and award dated 13/10/25 passed by the learned member MACT Aizol in MACT case number 51 of 22. Full stop. Notice upon, though it is submitted that notice upon drawing attention to the office note dated 23/2/2026, the learned counsel submits that though notice has been taken upon the sole respondent / awardee, right? You were,
My lord, there are 5 respondents.
5 respondents
Yes, my lord.
and 4 others, I see.
Yes.
The names are,
Names are on
appeal-
page 2. My lord.
page?
Page 2 of the appeal memo. Memo of appeal.
Oh, yes. These were the claimants?
1, 2, and 3 are the claimants, and they will be represented by their counsel, my lord.
You are for the, you are 4 and 5 are?
1 to 4. 1 to 3.
Okay,
1 to 3.
claimants.
Yeah.
And 4 and 5 are
4 is the owner of the offending vehicle, and 5 is the driver.
driver. So you have to take steps,
Yes, my
I
lord.
guess. 5 respondents have been impleaded, out of which respondent number 1, 2, 3 were the claimants before the tribunal, and 4 and 5 are the owner and driver respectively of the offending vehicle. Full stop. Learned counsel appears on behalf of respondent number 1, 2, and 3. Copies, you have 1, 2, and 3.
Yeah.
Have you received copies earlier? You have
Yes,
received copies?
yes, my lord.
Yes, and submitted that copies have already been received. Steps upon respondent number 4 and 5
Yes, my lord.
shall be taken by speed.
My lord, if we may await for the service report, because we have taken
Also, yeah.
steps on.
I see.
Yes.
Okay. Await service report with regard to respondent number 4 and 5.
Yes,
That
madam.
will do. In the meantime, we can admit this. It has not yet been, we should admit it, right?
Yes, my lord.
You file a separate IA for stay. We'll take it up later.
Okay, my lord.
There's no IA here.
Yes, no IA.
Yeah, there's
If
no
required,
IA.
we can file the IA, my lord.
Yes, yes. In case of this thing, if you want to stay, you have to file an IA,
Yes, my
I
lord.
guess, and then deposit 50%.
Yes,
of
my
the
lord.
amount.
I'll take instructions from
Oh,
my senior
no,
and my.
no problem.
Yeah, okay.
Don't worry, no problem. But we'll let us admit it. What do you say? The appeal is admitted. Full stop. Call for the original TCR of MACT case number so and so 51 from the. This will take it forward. Okay. List the matter in the orders column after
2 weeks, my lord, if possible.
3 weeks.
Much obliged, my lord.
Item 4.
My lord, in this case, the respondents are yet to comply.
Several pleadings have already been filed,
Yes,
right?
my lord.
In this-
My lord, I was instructed to represent respondent number 1. I just received the petition copy from the petitioner. Then I may be given some more time for filing my so-called reply.
My lord, this is a case where the respondent number 7, who was not originally impleaded, was impleaded later.
That is the problem in contempt, it keeps changing.
Yes, my lord. And my another friend has received the contempt petition on 19/1/26. My lord, as a counsel for the petitioner, my lord, today we are expecting a good news from the respondent that we will be paid, or the judgment and order of this honorable court may be complied with without any condition, my lord. So it is my humble prayer that they have to comply with the order of this court, since their SLP review petition
Okay.
has
yes,
already
sir.
been
I
dismissed.
have, you are basically seeking, writ petition was filed to get the section 34 interest.
Along with the market value and this interest under section 23 and 28.
My lord, I'll be filing my power today.
So, my lord, this may be kept on a short date. Otherwise, this has been pending for around 7 years, my
This
lord.
actually, it's been, it's pending for quite a long time.
Yes, my lord.
And yeah, we can actually, it will necessitate a hearing, it seems.
Yes.
Anyway,
And the counsel for the NPCC is here also. I think he refused to come up here.
not counsel,
I think he should at least come here and say something, my lord.
you are expecting the, not counsel for the, this thing, appears for the contempt petitioner, and submits that the matter has been pending since 2021. And the contempt has been initiated for failure of the respondents to pay the compensation amount in terms of the order passed by this court. Order passed by this court.
The order is 4/12/2019, my lord.
4/12/2019
In WPC.
WPC number
71
721
of 2018.
2018.
2018.
Full stop. It is submitted that the said order has also attained finality. Now, let me make a note of this. This will be helpful for. It's also mentioned in some previous orders also. How many respondents are there now?
7, my lord.
7 respondents have been impleaded,
Yes. Now,
and out of which the file is very voluminous because of the number of petitioners. A lot of petitioners are there.
Your Lordship may kindly see the order dated 24/3/2025.
24/3.
Yes, my lord.
24/3, right? Which respondents have filed?
Respondent 4, 5, and 6 have filed their affidavit, NPCC. Now the secretary,
It is submitted by the learned counsel for the petitioner that by this time, respondent number 4, 5, and 6
yes, my lord.
out of the 7 impleaded respondents, 4, 5, and 6 within bracket, right? NBCC have filed their counter affidavit. learned counsel appears on behalf of you for the one. You for one.
One.
For respondent
one.
number 7, my lord.
Huh?
Respondent number 7. She's for the respondent number 7.
For 7.
Yes.
Yes.
Dr. Rajendra Kumar is the Secretary Ministry of Home Affairs.
Respondent number 7 submits that she'll be filing her authority power today and seeks 2 weeks time.
Yes, my lord.
2 weeks time to file affidavit/pleading, if any. Prayer is allowed. What about the other respondents?
The other respondent has expired and
1,
some
2,
of the-
3.
Yes, they
So
are
4,
not
5,
necessary
6 have filed.
Yes.
7 she will be
Now,
filing.
7
1,
is
2,
the-
3.
now. Yes, my lord.
Newly implemented and all.
This is the newly implemented
Yes,
respondent, and he is important in this case.
Okay, no problem.
The others
Let it be there.
are not that necessary.
This is sleeping. It's slept. Who's appearing for respondent number 1, 2, and 3? I'll check. They have been noticed.
They have been noticed, they have received notice, and in fact, Mr. Roshan Subedi used to appear. In
This
favor
is
of
1,
NPCC.
2, and 3 are also National Projects Construction Corporation.
Yes, my lord.
Right? So they have, it is submitted that respondent number 1, 2, and 3 have also have received notice, but none has appeared so far. Right?
Yes, my lord.
None has appeared so far. But they will be necessary. They will be essential.
Respondent number 7 is the main
Most
party now.
important. 1,
most
2, 3,
important.
okay.
Yes, 3, 4, 6.
So we,
3 to 6
for
and
the
7.
moment we proceed. Okay. List the matter after 3 weeks.
My lord,
2 weeks.
2 weeks, and if some strong observation may be made by this honorable court, because since this matter has been pending.
Yes, I have made
for-
already.
Yes, my lord.
This has been pending. It is submitted by the learned counsel for the petitioner initiating this contempt proceeding that the matter was registered in 2021 arising out of judgment and order of 2018, and he seeks expeditious disposal of this expeditious adjudication of this proceeding. This much will do.
My lord.
List after 2 weeks or 3
2
weeks?
weeks.
Obliged.
Obliged.
This will require a hearing, This, they could have appeared and just at least made their stand known.
They have appeared 3 to 6 in the last court date.
No, 1, 2, 3.
Yes.
But here, in this proceeding, they have not appeared.
Obliged.
Item 5.
Yes,
Please,
sir.
Your Lordship. My Lord, as per office note dated 23 February 2026, AD card is still awaited in respect of respondent number 2 and 5. Office note dated 2302.
I've seen. You're Mr.
Lalfa Koma.
Learned counsel. I appears on behalf of the
Appellants.
appellants herein. Ten in number. Full stop. You are the defendants or the plaintiffs?
I was the plaintiff, Your Lordship.
The appellants are stated to be plaintiff, stated to have been the plaintiffs in the suit before the learned court below. Three respondents have been impleaded, and respondent number 4 to 7 are pro forma respondents. Full stop. It is submitted that notices have been sent on all the respondents, right?
All the respondents.
And so far, no service report has come. As per office note dated 23/2/2026, service report is has not yet come with regard to respondent number 2 and 5. What about the other respondents?
Others are yet to be represented despite service of notice.
They have been served?
They have been complete, Your Lordship. And I would like to take Your Lordship's kind attention to in respect of respondent number 5, Your Lordship, if possible, which is at page 6 of my appeal memo. Out here, Your Lordship may notice that the address of the respondent 4, 5, and 6 are identical.
Okay.
So despite service of notice being completed in respect of 4 and 6, for some reasons, it cannot seem to reach respondent number 5. Since they all are representative of the same company,
I see.
if deemed notice may be drawn against respondent number 5 only at this stage.
Address is same.
Address is the same, just that the designation are different. 4 is the president, 5 is the chief executive officer, whereas 6 is the chief financial officer. All belonging to Gammon Company Private Limited. In fact, 7 also belongs to Gammon Company.
I'm just going through the previous, any order, specific order, previous order you want to bring to my notice? To help?
As far as 6 and 7 is concerned, Your Lordship, as per office note dated 26 June 24.
26 June 2024.
Sorry, AD was returned on 26 June 24, and this is reflected in office note dated 28 6 24.
28, 6, 24. Uh, 26?
No, my lord, 28 6.
28 6. 28 6. This is 26 6. No, 28 6. As reflected in the order dated 1/7/2024, services deemed to have been served on respondent number 6 and 7. As already mentioned above, service report is awaited with regard to respondent number 2 and 5. As reflected in order dated 1/9/2025, this will help us.
My lord,
As
definitely.
reflected. Substituted service by way of newspaper publication was taken upon respondent number 3, and service deemed to have been complete. Full stop. As per office note dated 16/10/2024, notice upon respondent number 1 and 3 is complete. So everyone is served except 2 and 5 now.
2 and 5.
It is submitted by the learned counsel that accordingly all the respondents have been served except respondent number 2 and 5. However, none of the noticed respondents have chosen to appear till date. It is also pointed out that the postal address of the served respondent number 4,
6, 7
4, 6, and 7,
are identical to 5.
located in the city of Mumbai, are identical. And therefore, the Learned Council submits that perhaps notice upon respondent number 5 may be deemed to be complete. Well, President, Chief Executive Officer,
Moreover, they're performer respondents, Your Lordship.
they are performer respondents. Okay. Not essential, not very essential.
Yes, Your Lordship. I mean, it will not really prejudice them. They are just, they're not exactly necessary. Although they're a proper party, they may not be a necessary party.
We can wait for a little while,
Very well, Your Lordship.
and then on the next day we can take a call on this, right?
Absolutely, Your Lordship.
Full stop. For the moment, however, the service with regard to respondent number 2 and 5 may be awaited. Any other, no point taking fresh steps by speed post, right?
No,
Do you
really,
think
not
so?
really, not really, Your Lordship. Because number one is that we cannot locate the respondent number 2.
Yes, yes.
He's no longer residing in the last known address.
Okay. So how, okay.
And as per our information, he was holed up in some jail in Itanagar. I don't know whether it's central jail or
Okay,
district
okay.
jail.
Then with regard to 2 also on the next day.
We will take it up in the next court date.
Okay. To 2 also you can perhaps consider substituted service on the
Absolutely.
next day. And 5 we wait.
We can wait.
Email also, if you have the email, you can also send an email. Email notice is accepted nowadays. No problem.
I shall make it an endeavor, Your Lordship.
The petitioner, the appellant may also consider sending an email notice to respondent number 5 at its address, if it is available. List the matter after.
3 weeks. I am going to be out of station for the next 2 weeks, that's why, Your Lordship.
We can admit the matter in the meantime.
Absolutely, Your Lordship.
The appeal is in the meantime admitted, full stop. Call for the
TCR, Your Lordship.
it's call for the TCR. It is against injunction.
No, my lord. It's basically the cause of action in this particular case arises out of a contract between the parties. Now, in the contract, there was a particular clause saying that any dispute between the parties shall be governed by the civil courts in Guwahati. So,
Civil courts in Guwahati.
despite the fact that the cause of action arose in Aizawl, the parties all are from Mizoram. So the issue that I've raised before this honorable court is whether a contract can take away the jurisdiction of the civil court as envisaged under section 17 of the CPC.
There are some judgments on this point actually.
Yes,
This
Your Lordship.
Standard form contracts, all disputes subject to Delhi jurisdiction, Bombay jurisdiction.
In my humble opinion, Your Lordship, I don't think they can take away the jurisdiction as provided under the
I will not
law.
express any opinion now, since I might have to decide, but there are some judgments we can
My
look up at the time of hearing. It's admitted. Call for the TCR of, just help me with this.
Hardly any TCR, Your Lordship. It was preliminary hearing.
Okay. TCR is not necessary.
We only filed, they only filed some written statement. After that, in the preliminary stage, it was dismissed.
I see. Okay. The case record, scan copy would do, I think.
Scan copy will do.
Scan copy of civil suit number 45
My lord.
of 2021. From the Court of the Learned, Civil Judge, Senior Division 5, Aizawl District, Aizawl Judicial District. Okay. List the matter after
3 weeks, Your Lordship?
4 weeks.
4 weeks. Very well.
I can give 3 weeks also. So
Deeply obliged.
4 weeks.
4 weeks it is.
Item 6.
My lord, in this matter, we have filed one IA. IA is regarding implement of the new incumbent, my lord. The respondent number 4 has been replaced by my lord, respondent number 7, and respondent number 6 has been replaced by respondent number 8. And respondent number 4 is Chief Engineer Vinod Kumar, and he has been replaced by A.K. Mishra, my lord. And 6 is Harjimal Meena, and he has been replaced by Arvind Kumar Meena, my lord.
I see.
That is our prayer, my lord.
This was regarding the payment of interest,
Yes, my lord.
right?
Yes. On the last occasion,
Lord,
my
an
lord,
writ appeal has been filed, my lord.
Yeah. You are appearing from Delhi?
My lord, I am appearing for the no, my lord, from Guwahati, my lord.
Guwahati. Yes, yes. Let me peruse the file.
Guwahati bench, my lord.
You are Mr. Silo?
H. Saudin Sangha, my lord.
Okay. Jyoti Sangha.
My lord, a copy of the IA has not been served upon us, my lord.
You are representing?
My lord, I am representing the earlier contemners who now is stated to be, my lord, I have on the last occasion mentioned that they have been transferred. Earlier I was representing 3, 4 and 5. So 3 is still there, my lord. 4 and 5, they have been transferred. So already, my lord, the applicant has filed the IA, my lord, for including the new contemners. I am just requesting for a copy of the IA, my lord, that can be.
Yeah, you'll get your copy, the petitioner. This is a big problem for the in contempt petition. They keep on changing.
Yes, my
So you
lord.
have to,
It keeps on changing
It
during
is
the
also
pendency
a cause
case,
of
yes.
delay, actually.
Yes.
And Lord Counsel for the
There
petitioners.
is an appeal file, my lord. here,
Petitioners
this matter.
107 in number have initiated this
We are not
contempt,
on the appeal, my lord. We are in the contempt, my lord.
initiated the contempt aggrieved by alleged non-compliance with the order dated so and so passed by this court in order dated 11/8/2023 passed by this court in WPC number. You can help me with the number?
76 of 2023, my lord.
76 of 2018,
23.
23,
Yes, my lord.
whereby the petitioners were, whereby it was directed that the writ petitioners be, whether it was directed that an assessment for payment of interest under LA Act 1894 be made with regard to the petitioners for the stated periods and necessary orders to that extent may be made, full stop. The para 20 of the relevant para 20 of the said order may be reproduced herein below. Full stop. Six respondents have been impleaded. Who's representing one? Respondent number one. That's a railway authority, you know,
It's
Secretary
the
Railway Board.
Secretary of Railway, Secretary of Railway Board, yes, my lord.
Who, any idea who's representing? Mr. You are.
My lord, I can represent, my lord. But at the moment, my lord,
You can
the
represent?
Secretary is not the authority, my lord, to implement. I can represent, my lord, subject to the Wakalat. As a CGC, I can represent, my lord.
Okay.
But in contempt, my lord, since it is by name, my lord,
That's true.
the Wakalatnam will be required.
Yes, yes. True. Learned Counsel, your good name, please. Your good name, please. Who's appearing online?
H. Gupta, my lord.
H. Gupta. Learned Counsel.
H. Gupta.
H. Gupta. H.
H. Gupta, man.
Yes,
Yes,
I
ma'am.
get it. Mr. H. Gupta, Learned Counsel, appears through online mode from Guwahati, and for the moment he is representing respondent number 3, 4 and
3, 4 and 5. 5.
3, 4 and 5.
3, 4 and 5.
5 we have already impleaded, my lord.
I'll come
Six.
to that, I'll come
Yes,
to that.
yes.
3, 4, and 5. And what about 2? 2 also?
2 also, my lord. 2 also.
2, 3, 4, and
2,
5.
3, 4, and 5. I'm sorry.
It is submitted that
4 and 5.
he can also represent respondent number 1, but as the impleadment is by name, therefore, filing of a power would be necessary. You take instructions, it will be convenient if you represent her also, right?
My lord.
Okay.
Yes.
The
I
council
will,
shall
my
take instructions regarding
Yes.
the same. Full stop. Have you filed any written pleading on behalf of the respondents you represent?
No, my lord. No, my lord, we have not filed because during the pendency they have been transferred, my lord, and also there is a writ appeal already filed against this
It
order.
is submitted that it is Mr. Gupta submits that no affidavit has been filed on behalf of the respondents represented by him, and that in the meantime a writ appeal has also been preferred, and respondent number who has been transferred in the meantime? 4 and 5.
4 and 5, my lord.
Respondent number 4 and 5, the incumbents, the incumbents being respondent number 4 and 5 have also been transferred in the meantime. And 6, you have filed an IA.
For 4 and 6, I have filed IA, my lord. Respondent number 4 and 6, my lord.
This main petition will list after
2 weeks, my lord.
3 weeks.
2 weeks, my lord. Let it come out on 10, my lord.
List after 2 weeks. We'll take up the IA.
Yes, my lord.
This interlocutory application has been filed by the petitioner for impleadment of Mr. A.K. Mishra, Chief Engineer Construction Mizoram Project, NF Railway, Maligaon, Guwahati, and Mr. Arvind Kumar Meena, Deputy Chief Engineer Construction, Aizol, in charge of Kunpui and Bhairabi, NF Railway, Aizol, as respondent number 7 and 8 in the contempt petition. As in the meantime, the officials impleaded as respondent number 4 and 6.
Yes.
4 and 6 have been transferred. It is submitted that these two officials need to be newly impleaded, as they are presently holding the position previously held by respondent number 4 and 6.
Yes, my lord.
Right. So you will issue notice to them?
My lord, here the IA usually dispose, since there is no prejudice will be caused against the respondent if they are impleaded. And then in the main contempt, notice was usually issued to the newly impleaded respondent, my lord, after allowing the IA, my lord.
Yes, yes, it will be allowed. It is submitted by the learned counsel that the two officials mentioned are presently holding the position, and their presence is necessary for the adjudication of the contempt petition and may be impleaded, full stop. Upon considering the matter, the prayer is allowed, and so may be impleaded as respondent number 7 and 8
Yes, my lord.
with this petition. The IA stands allowed and disposed of on the aforesaid terms. Void order dated so-and-so, 24/2, passed in IA 41 of 2026, allowing and disposing of the same, dash, full stop, the petitioner shall take steps upon newly impleaded respondents 7 and 8.
Yes.
Now you'll file a fresh sheet?
Yes, my lord. I'll change the course title.
Yes, yes.
And notice will be required, my lord.
Yes.
And
Notice
in
will be
respect of number 8, my lord, if I may be allowed to take the stay,
Okay.
since he is in the same city, my lord.
No problem. The learned counsel submits that he shall submit a fresh cause title
Yes,
pursuant to the additional implement.
yes.
Full stop. As prayed for, the petitioner is allowed to resort to dusty service with regard to newly implemented respond number 8.
Yes, my lord.
This is the matter after.
In respect of number 7, by way of steps. Yes.
Speed post.
Yes, my lord.
Steps upon respond number 7 shall be taken by speed post. That's I understood nowadays. Same post.
If my learned friend can accept notice, my learned friend can accept notice on behalf of the respondent number 7.
Can you?
No, my lord, since it is a contempt, my lord, notice has to go first.
Okay, okay.
And then they will ask me
Then
to appear.
they will instruct you. Then.
Yes,
That's true. That's true.
That's obliged.
List after
Yes,
3
yes.
weeks.
Yes, my lord.
Item number 7.
May it please, Your Honor. Your Lordship, as directed by this Honorable Court, in its order dated 14/11/2025, passed in IA numbers 109 of 2025, we have submitted 50% of the awarded
Right.
amount.
And for stay of the impugned judgment.
My Lord.
And my lord, at this stage, since the amount deposited is undisputed amount, the claimants who are the respondent number 1, 2, and 3 may be allowed to withdraw the same from the registry of this court.
Yes. Subject to the usual formalities, bond and all these.
Yes, subject to.
In the meantime, Your Lordship, if Your Lordship may be kind enough to reflect the amount as well as the check number in the order sheet, if possible.
Heard. So and so. For the appellant insurance company, who submits that in terms of order dated
14/11.
It's in the IA, Your Lordship, IA 109.
You can just help me with that.
Yes, Your
14/11/2025,
25,
passed in IA number
109 of 2025.
25. The regarding stay of the impugned judgment, comma.
Delay, condonation of delay.
Oh, it's a condonation of delay. And we don't write anything. The appellant insurance company has deposited 50% of the awarded amount, being rupees
68,
6
68,
68,
64,
64,
100, 100.
100, 68 lakhs.
Yes, Your Lordship.
What was the award? More than a crore.
Yes, Your Lordship.
Huge award.
Huge amount.
Anyway, so nowadays the price value has also increased. There's no value for human life. Anyway. White check number
647-313,
647-313 dated
4/2/2026.
4/2/26, drawn on which bank?
Axis Bank.
Axis Bank.
In favor of Registrar Guwahati High Court, Aizawl Bench.
You are representing the claimants.
The claimants, respondent number 1, 2, and 3.
What about 4, 5, and 6? They have appeared.
No, my lord. I don't think there will be a necessary party in as much as they are only challenging the quantum,
Pro forma, actually.
not the
No,
liability.
only challenging the quantum.
Quantum, not the liability.
Okay. Not the liability. So what do you say, sir? 4, 5, and 6 Should be, it'll remain like, a notice has been sent.
Notice has been sent. We can wait for some time, Your Lordship. Otherwise, they might
Yeah.
suddenly turn up and say that we were not given
Yeah, that is
notice.
true, always, respond number,
Just as
services.
an abundant precaution, Your Lordship.
That's true, I agree with you, partly. Service await service upon respond number 4, 5, and 6. Full stop. The learned counsel for respond number 1, 2, and 3, who were claimants before the tribunal, submits that they may be allowed to withdraw the deposited amount, which is 50% of the award, full stop, as mentioned above. The prayer is allowed, the claimant side shall be, are hereby allowed to, they may be allowed to withdraw the amount deposited by the appellant before the registry of this court, subject to proper identification and also submitting of a bond and other usual formalities.
So required.
We can, it's come for, we can admit also. In the
Admit
meantime.
and call for records. Your
Yes,
Lordship.
yes. In the meantime, the appeal is admitted. Call for the original TCR of MACT 1 of 21 from learned member MACT Aizol. Okay.
Your
Is the
Lordship,
matter?
Your Lordship, if I may, although it may not be absolutely necessary, but I have filed one more IA. This is 110 of 2025. This is for stay of the judgment and order.
You have deposited also. List the matter in the main appeal, in the orders column, after 4 weeks?
4 weeks.
Enough, 4 weeks. Where is the IA?
This is 110 of 2025.
Can I have the file? IA file. Rest of the award we can stay.
Yes, yes, man.
They have deposited, they've complied also.
They're very content now.
Huh? No.
They're very content now.
The instant interlocutory application has been filed by the appellant insurance company seeking under Order 41, Rule 5, CPC read with Section 151 of the CPC for stay of the judgment and award dated 5/3/2025 was by learned member MACT Aizol in MACT case number 1 of 2021. The main appeal has been admitted, semicolon. The appellant insurance company, in terms of the order of this court, has deposited 50% of the awarded amount, and the claimants who are respond number 1, 2, and 3 in the main appeal have also been permitted to receive the deposited amount from the registry, subject to the usual formalities. In the learned, in the given facts and circumstances, till the disposal of the appeal, the judgment and order dated so and so, shall remain stay.
Deeply obliged.
Obliged, my lord.
IA stands allowed and disposed of.
Item 8.
Your Lordship, in respect of item number 8, I'm afraid I'll have to seek Your Lordship's indulgence. There was a bereavement in my family over the weekend. There was a bereavement in my family over the weekend, so the matter may be taken up on a different date if possible.
Sure, sure. Yes, you're for the respondent.
Yes, I'm for respondent number 1, my lord. If possible, it may be taken up on 2nd of March, next Monday.
This coming Monday, Your Lordship.
Will it be possible for you?
It should be possible.
Okay. Mr. Land Council seeks some accommodation today due to a family bereavement. You are for all the respondents?
I'm for respondent number 1, my lord.
I'm for respondents 3 to 7.
A legal aid counsel was appointed on behalf of respondent number 2, but we are mainly concerned with the respondent number 1 plaintiff.
Learned Counsel appears on behalf of respondent number 1, and Madam represents respondent number 3 and 7. It is submitted by that legal aid counsel. Do you know his or her name?
I will inform him, my lord.
The legal aid counsel was appointed for respondent number 2. Full stop. And petitioner counsel undertakes to inform the counsel as Lord counsel is not present today. Full stop. Okay, so admission order and all that
I think at this stage, I think I have my learned friend has some reservations regarding the admissibility of this.
Okay, then we keep it open.
Yes, ma'am.
Then we keep it open. List the matter on 2/3,
My lord.
2026. Fine.
Deeply obliged.
Much obliged, ma'am.
Here, 3rd March is also a working day.
My lord.
In Guwahati, it is 3rd and 4th are holidays, but here only 4th is a holiday.
Yes.
So you have the option of taking it on 3rd also. Anyway, so
Yes.
second.
Obliged, Your Lordship.
Item 9.
Yes, Your Lordship. I'm representing the state government, respondent number 4 and 5. And I'm seeking another 2 weeks' time to file my affidavit, Your Lordship.
My lord, similar prayer for respondent number 1 to 3. Union of India.
This writ petition has been preferred by 417 writ petitioners. Full stop. This is regarding land compensation?
Yes, my lord.
Regarding land compensation. Just a nutshell. Full stop. 9 respondents have been impleaded. Ma'am is representing you for 1.
1, 2, and 3.
Ma'am, learned counsel, so and so appearing for respondent number 1, 2, and 3, 6 2 weeks time to file an affidavit. You are for respondent number
4 and 5.
learned counsel appearing for respondent number 4 and 5 as a similar prayer. The prayers are allowed 4 and 5. Then what about 6 to?
My lord, as for the respondent number 6 and 7, one of the counsel, Mr. P.C. Thamo, had informed me that he had instruction to appear on their behalf. And as for the respondent 8 and 9, we may wait service report in the meanwhile.
That's a full stop. So we can wait for the next day
Yes,
for
my lord.
appearance
Yes,
of
my lord.
6, 7, and 8. Full stop. Service report awaited with regard to respondent number 9. Mr. Lord Counsel submits that Mr. Jonathan submits that he has received information that perhaps learned counsel would enter appearance on behalf of respondent number 6, 7, and 8. List the matter.
6 and 7. 6 and 7.
6 and 7. 8 and 9 awaited.
8 and 9, they were from same department.
Awaited.
Awaiting.
Awaited on not 9, man. 8 and 9. List the matter after 3 weeks. I
Yes,
think.
my lord.
That will be better.
Obliged.
Deeply obliged.
Item 10.
Can I have the glass? I can reach now. I can
May
reach.
it please your lordship?
Just a minute, yes. Read petition. Item 10.
May it please your lordship, on behalf of the state respondents, this is the second time the matter has been listed. If I may be granted at least another 3 weeks' time to file the necessary counter affidavit, your lordship.
Oh, it's electrocution compensation.
Yes,
Yes,
sir.
lordship.
Yes, yes, I'm gone through this. You are Mr.
Yes, mga isama.
Learned Counsel. And this writ petition has been filed for seeking compensation for
27 lakhs.
Compensation of 37 lakhs. 27 lakhs for death in electrocution of the petitioner's grandson.
Yes, lordship.
Grandson. The petitioner's grandson, the victim. Full stop. 10 respondents have been impleaded. You are for 1 to?
1 to 10, Your Lordship.
All of them?
Yes, Your Lordship.
Third counsel represents all the 10 respondents and seeks 3 weeks?
Your Lordship, if 3 weeks time may be granted, because there are 2...
No issues.
Yes, Your Lordship.
3 weeks time to file affidavit if any. That's okay?
Yes, Lordship.
Let the matter, let them file a counter. List the matter after 3 weeks or
3
4
weeks,
weeks?
Your Lordship. 3 weeks, Your Lordship.
List the matter after 3 weeks on a date to be fixed by registry.
Much obliged, Your Lordship.
Much obliged.
Orders, item 11.
Please, Your Lordship, this is an application
Anticipatory bail?
for anticipatory bail of the applicant in connection with Kulikon, PS case 137 of 2025. The main grounds raised in the petition is that she has no involvement in the case and that she was merely present at the place of occurrence in order to recover some debt which one of the co-accused had promised to pay her if she also went with her. And additionally, Your Lordship, we had also filed an additional affidavit with regard to her medical conditions.
Okay. She is not named in the FIR?
No, Your Lordship.
Okay. What is the, shall we see the FIR first? Page 23.
Page 23 is the statement of the complainant.
Okay, let us see the FIR first. Okay.
FIR is at page.
Okay. You can read it or I can also go through it.
Yes.
Madam Linda, you appeal?
Yes, madam.
Any instruction? Let me see the FIR first. Case diary has been received?
Case diary was next in the petition itself, Your Lordship.
Submitted. Let us see the FIR first.
FIR is at page 18, Your Lordship. The translated copy is at page 19, if I may read, Your Lordship. On 1/12/2025, who James Zolian, presently working at so-and-so and permanently residing at so-and-so, submitted a petition before the Superintendent of Police seeking assistance for the registration of an FIR. In his petition, he stated that on 20/11/2025 at around 11:30 a.m., he, along with a person known to him as Anthony and one Mickey from their locality, met at Falkland after bringing money intended for the purchase of land. Thereafter, two of them proceeded towards World Bank Road near Trinity Hospital. Upon reaching the said place, they met one male and two females who had arrived in a Maruti Suzuki Fronx bearing registration so-and-so. Shortly after the meeting, two persons riding a Bullet motorcycle and coming from the direction of Trinity Hospital stopped near them. The two men, who were wearing what appeared to be police uniforms, approached them stating that they were searching for someone and proceeded to search them. It was alleged that a sum of rupees 17,40,000 which they were carrying was taken away. In connection with the said matter, a detailed and careful inquiry was conducted. It was revealed that on 19/11/2025, the complainant, James Zoliana, along with two associates from outside the state, namely Abdullah and Debua, had come to Aizawl to purchase meth. They stayed at Hotel Spice Corner, Falkland, where they discussed and finalized the matter of purchase and payment. On 2011, Anthony was sent to complete the purchase of the drugs. While they were negotiating the transaction, two persons arrived on a motorcycle, whom Anthony suspected to be police personnel, as one of them was wearing a jacket. They stated that they were looking for Mickey, who had accompanied them. Anthony, however, was instructed to leave and he left accordingly. It was further revealed that the three persons who had arrived in the car, along with Mickey, and two persons who had arrived on the motorcycles, in total 6 persons, shared among themselves the sum of rupees 17,40,000. The complainant, James Zolian, also submitted that he received a sum of rupees 50,000 from those persons. Since false information was submitted before the Superintendent of Police through the said FIR, and as money was wrongfully taken and distributed among themselves, it is prayed that necessary legal action may be taken against the persons involved. This was after the initial complainant had lodged the FIR. And the fresh FIR was lodged by the concerned ASI.
These people arrived in a motorcycle and took away the money.
That is the allegation.
Okay. Yes, ma'am.
My Lord, as per the information which I have received, my Lord, since she was present at the time of occurrence, and there is apprehension that this total amount of 17,40,000 was distributed among these 6 persons. That is why our investigation is being done against her also.
Okay. She was not named in the FIR, but
No, my Lord.
investigation has found her complicity. She was found to be involved in the offence by the
My Lord,
investigation? Not
as
yet.
per the information, nothing concrete has been found against her.
So I think we can grant interim and ask her to appear and record a
Yes,
statement.
madam.
And we
Your
can
Lordship,
keep
her
this
statement has already been recorded by the case.
statement has already been recorded.
Yes, Your Lordship.
Then we can dispose it off finally.
All right, my Lord.
That's okay. She may be an acquaintance of the said Mickey person named Mickey, right? Who's named in the FIR, I guess. Your good name, please?
Jonathan Lorenzo.
Jonathan. Learned counsel for the petitioner, and Linda from Learned PP for the state of Mizoram. First, the instant pre-arrest bail application has been filed invoking section 482 BNSS in connection with Kulikon PS case number 137 of 2025 under so-and-so section. Write it from there. The case was registered based upon a complaint dated 17/12/2025. The gist of the allegations in the FIR is that the miscreants took away a sum of rupees 17,40,000 from the complaint which he was carrying. Full stop. The present petitioner is not named in the FIR. Full stop. You have received the case diary.
My Lord, case
Instruction.
diary I have not received. They have annexed 1 copy, my Lord.
Okay. The learned public prosecutor submits that. Before that, you just write. It is submitted by the learned counsel for the petitioner that the statement of the present petitioner has already been recorded. Full stop. The same is not disputed by the prosecution, and Ms. Famwal, the learned PP, submits that though investigation has progressed, the investigation has progressed, and it is fairly submitted by the prosecution that nothing concrete has been found against the petitioner so far. Full stop. In view of the same, and as also the statement of the petitioner has already been recorded, therefore, I am of the considered opinion that it would be just and fair to allow this prayer for this application for anticipatory pay. In such view of the matter, it is directed that in the event of arrest of the petitioner in connection with so-and-so case, she shall be allowed to go on bail of rupees 30,000 with one surety of the like amount to the satisfaction of the arresting authority, and subject to the condition that she shall render full cooperation to the remaining investigation. She shall appear before the IO as and when necessary. She shall not hamper or tamper with evidence. Violation of the bail conditions might entail cancellation of the bail. The bail petition stands allowed and disposed of.
Much obliged.
Item 12.
My Lord, if we may be given 3 weeks' time in this matter.
You want after 3 weeks? After 3 weeks?
After 3 weeks, my Lord.
Learned counsel for the appellant who has also filed the instant interlocutory application.
Yes, my Lord.
3 weeks time for the matter. Full stop. You are appearing for the
State, my Lord.
state. All the respondents are state
No, my
respondents?
Lord. Private respondent is respondent number 6, my Lord.
Okay, 1 to 5 are state
State,
respondents. So appears on behalf of respondent number 1 to 5. What about 6? Notice has been sent already?
Yes, my Lord. They've been represented, my Lord.
They've been represented also?
Yes, my Lord.
Okay. It is submitted from the petitioner side, from the applicant side, that respondent number 6 has already entered appearance.
I think he has even filed his objection, my Lord, to the IA.
What is the IA about? Just ask.
Condonation of delay, my Lord.
Okay. The IA is stated to be an application under Section 5 Limitation Act for condonation of delay in preferring the appeal. As prayed for, release the matter after 3 weeks.
Obliged, my Lord.
And main appeal, what do you have to file? What is the order?
Main appeal.
Oh, it's not.
It's not.
not
It
yet
will
open.
come up after the disposal of the IA, my
That's
Lord.
true. In the districts of Assam, I have seen this. They are registered a number along with the delay condonation.
Yes, my
But
Lord.
in the principal seat, they do not register. I think that is a more
Yeah,
correct.
only after
That
the-
is a better and more correct practice.
Yes, my Lord.
Because without condonation, the proceeding is not yet born. Actually.
Yes, yes.
Yeah?
Exactly.
So maybe we can have a uniform thing.
Item 13.
Just having a look. Okay. Hearing notice. How many are adjourned? All are adjourned, except this. Okay, one and five. What is the IA about?
Lordship, this is the application for condonation of delay.
Okay. There are 2 IAs?
There are 2 IAs, Lordship.
One is for condonation of delay.
Yes, the 27 of 2025 is the condonation of delay in special leave petition. This criminal appeal is against the acquittal, Lordship.
Okay.
And the applicant
And
being
IA criminal 1 is?
Yes, this is the appeal against the judgment and order, wherein the learned CJM had acquitted the respondents hearing. Lordship.
And what about the other IA?
Other IA is this condonation of delay, application for condonation of delay in criminal appeal.
In the criminal appeal?
Yes, Lordship.
Okay.
And since this is an appeal filed by the Union of India, so special leave petition is required as per BNSS, Lordship.
Because it's an appeal against acquittal.
Very true, Lordship.
You have filed an objection, right?
My Lord, I have filed my objection, and my Lord, on the last occasion, my Lord, although there is no observation made by the previous court, my Lord, there was one point raised by this honorable court regarding the provision invoked in the IA. This is leave for appeal against acquittal, my Lord.
Can I have a
under
Limitation Act and BNSS?
BNSS, Section 419 of 419 subsection 5.
Very true, Lordship. This honorable court had passed an order on dated 3/2/2026, Lordship. By this honorable court order dated 3/2/2026, and a query was posted before this court as to under what provision of law.
3/2, what is the date of the order you said?
3/2/2026. 3/2/2026.
Recent order.
Yes, recent order, Lordship.
3/2. Yes.
Yes, may take those. This operative is at paragraph number 3. At the outset, a query was posed before this court as to under what provision this court has the power to condone the delay prescribed under section 4195 BNSS. And I was given some sort of accommodation to answer the query, Lordship. And I
Right.
have done the research regarding that.
I'll come to that, okay.
Sure.
Appeal by the
Section 419, subsection 5.
appeal against equity.
Lordship, yes.
Subsection 5.
Subsection
No
5.
applications were entertained by the High Court. Expiry of 6 months and 60 days. Okay. Okay. So, the complainant is a public servant.
Yeah, the complainant is the Assistant Commissioner.
The informant of the case.
Lordship, yes.
The informant of the case. So in this case, your 6 months will be applicable.
Yes,
He's a public servant.
Yes, public
Assistant
servant.
Commissioner
6 months is applicable. And
Assistant
after
Commissioner
deducting
of
the
Taxes.
6 months, and there is a delay of 344 days. Hence this application.
About a year. So limitation period is 6 months.
6 months.
From the date of acquittal. Okay.
CVS.
An appeal against acquittal is, I think, what is the limitation period? I have to brush up. 90 days?
90 days.
90 days.
In the normal.
Okay. So, 419 subsection 5
Lordship,
is
yes.
silent.
Is silent.
Prescribed the limitation period.
Is silent,
Prescribed-
Lordship. This section 4195 does not expressly exclude the applicability of the Limitation Act. So the Apex Court in a numerous cases has stated that the application of section 5 of the Limitation Act stands excluded only when it is expressly or impliedly stated by the law. So here in this case, this section 5 of the Limitation Act is applicable.
Okay.
So the problem is that it was inadvertently not included section 5 in this application.
Mhm.
So this is a procedural error. Lordship have inherent power under section 528 of the BNSS. So for the interest of justice, at this stage, my prayer is, Lordship, I may be allowed to make necessary change or amend to include section 5 of the Limitation Act, since this is a procedural error on the part of the applicant, Lordship. And no prejudice would cause to the opposite parties.
In any acquittal, definitely the accused, the former accused, is likely to oppose, because he has got it's a very powerful thing,
Yes, yes.
being acquitted from a criminal case. And if anything tries to reopen that, obviously he will try to oppose. And regarding this implied, I will give you an example. For example, say that the particular provision which provides for a limitation period says like this, that in the event of delay, suppose in the section itself it is mentioned, that in the event of delay, the court can condone it, subject, however, to the outer limit of, say, 30 days. Then you know that that is the code, complete code. There can be no further extension. Then, because the extension provision is incorporated in the section itself, that would be a sure, sure implied exclusion of section 5. But here it is not like that; it's silent. So, first, what do you have to say? He wants to amend his petition first.
And Lordship, there are so many Supreme Court judgments which I have relied upon regarding that section 4195 does not expressly exclude the applicability of the Limitation Act. Lordship. If it is required, then I can produce.
We may have to look at section 29(2) also of the Limitation Act. We'll see. Let him amend then. Otherwise,
Yes, my Lord.
Let him amend the petition. You have filed a written objection, right?
Yes, my Lord, I had filed.
You will have to file a fresh application.
Lordship, I may be allowed to change the course title.
Course title. Tell me.
Yes, my Lord. Subject to the manner in which they have made the application, I may be allowed to file my reply.
Yes,
Fair
you
enough,
can.
fair enough.
You can, why not? Heard. So for the IA 27, just correct me if there's any error dictating. IA 27 of 2025 has been filed. No, you cut it like this. The applicant herein being the Union of India represented by the Assistant Commissioner Customs Division, Aizawl, Mizoram, give a dash, is seeking to file an appeal against the judgment and order dated 25/1/2024, passed by the learned CJM Champai Judicial District in criminal complaint number 16 of 22, whereby the accused class respondent was acquitted. Sole respondent, right?
There are three respondents.
The accused persons / respondents herein were acquitted. Full stop. However, as per the applicable procedure, the prospective appellant has filed a leave petition seeking leave to prefer that appeal. Full stop. Further, there is a delay of 344 days in preferring the special leave petition. For which the interlocutory application filed has been registered as IA criminal number 27? 26? 27 of 2025, full stop. It is submitted that there is also a delay in preferring the criminal appeal against acquittal, for which a delay condonation petition has been filed and which has been registered as IA criminal number 26. Is it 26?
No, Lordship, 26 is...
I think 26 is
No,
the...
no, 26 is special leave petition.
And
And in that criminal...
27.
Ah.
The first one, madam, is 26. This will be 27.
27.
Full stop. And we will pass the order in IA 27 now. Okay, full stop. The respondents have also filed a objection to the leave petition, to the application seeking condonation of delay in filing the leave petition. Full stop. It is submitted by the learned counsel for the petitioner that though the interlocutory application is about has prayed for condonation of the delay, but specific inadvertently specific reference to Section 5 of the Limitation Act was not made, and seeks permission to correct the same by submitting a fresh cause title. Full stop. Learned counsel for the respondents submits that in the event of the prayer being allowed, they may be given the liberty to file a reply. Full stop. I've considered the matter. The necessary amendments may be made by the applicant, incorporating the provisions of Section 5 of the Limitation Act. The respondents are at liberty to file any reply thereof. Full stop. This is the matter after 3 weeks.
3 weeks.
So there is a delay. There's quite a it's a bit of a mess actually. You know, there is a delay, and then in the leave
Yes,
allowed,
yes.
then again you encounter
Very true, that's it.
other delay of the
Other
appeal.
delay.
So obviously they will have they will not leave you alone. They will be also definitely aggrieved. Okay, fold it up.
Item 14.
Cause list is gone also. Just a minute. Yes, 14 is
Yes,
also
Lordship,
similar.
Yes, similar case, Lordship. Here in this particular case also, that inadvertently Section 5 of the limitation was not included.
Okay, same.
Same,
It will be
Lordship.
similar order.
Yes, yes.
You have filed an objection in this
I had
also.
filed my objection. I think similar order can be passed.
Yeah, similar order. It will be similar order. The only thing is that
Date may be changed. Your
date
Lordship,
will have to be changed. Huh? You just keep it blank. I will correct it later. Or it can be given from this. Okay, you leave it dot dot dot. I will fill it up now later. IA in this with IA. There are 3 IAs here.
3 IAs, Your Lordship.
What is the third IA here?
The third IA is the application for continuation of delay in the criminal appeal.
Criminal appeal, that's one. Then leave petition.
Leave petition
Is one
also-
criminal, one IA.
Yes.
Delay leave petition is
Yes,
another
yes.
IA.
There
In the
are
earlier one
several.
also we had 3. In the
3,
earlier
yes. Earlier also 3.
So first we will be passing the order in the IA pertaining to the delay condonation of the leave petition.
Very true, Your Lordship, yes.
Same order. No? Just keep it dot dot dot. I will fill up the blanks.
Item 15.
Yes, may it please Your Lordship, I am for the appellants. And in terms of the order dated 19/2/2026, my lord, we have filed the proper documents, the newspaper publication, the specific newspaper, my lord.
This Caroline, you are paying for the response?
State respondents.
All right. Ms. Rosie,
Yes, yes, my lord.
Large Counsel, appears for the 3 applicants herein, full stop. 6 respondents have been impleted, full stop. Ms. Caroline, Learned Government Advocate, appears on behalf of respondent number 1, 2?
No, my lord, 2 to 5.
2 to 5, I see. Okay, 1 and 6.
1 and 6 private respondents, my lord.
In terms of order dated 21/11/2025, as by this court, the appellants resorted to substituted service by newspaper publication in two newspapers of Mizoram, and they have filed a compliance affidavit along with the newspaper copy. Service upon respondent number 1 and 6 deemed to be completed.
Yes, my lord.
None has appeared so far for the said respondents. This is for delay condonation, right?
Yes, my lord.
So we dispose it off on the next day, or?
Lordship, I will be filing my written objection.
Okay. Ms. Caroline, Learned Counsel for 2 to 5 submits that she may be given an opportunity to file written objection. The IA has arisen out of an application under Section 5 of the Limitation Act, by the prospective appellant seeking condonation of delay of 295 days in filing a regular first appeal against judgment and decree dated 5/4/24 passed by Civil Judge Senior Division 3, Aizol in civil suit number 51 of 2018. How much time?
3 weeks' time.
Yes, my lord. Well, obliged.
Item 16.
Lordship, this is a criminal revision petition, and this IA is again the
Delay
application,
condonation.
yes, 92 days in filing the connected criminal revision petition, Lordship.
Revision is against a bail order.
Bail order, Lordship.
I think, my humble opinion, subject to correction, is that revision, the bail is supposed to be a interlocutory order, actually. So revision, maintainability of revision has to be seen. However, you can file a you can file a criminal petition, 482. That may lie. That I think lies. But being a revision, specifically, it's a it has been held to be an interlocutory order, I think. Just check up the petition.
I'll check.
As far as I know, revisions don't lie against bail, but criminal petitions can lie. Cancellation of bail
I'll
can
check,
lie.
Lordship,
Even cancellation of, you are aggrieved by the grant of bail?
Yes, Lordship.
Okay. Were you the complainant?
Yes, Lordship, I'm the complainant.
You can also file cancellation of bail if it is the bail has been granted by special judge. So a higher court can cancel the bail also under 439(2). I don't know what is the new provision. Or 482 can lie. Ideally, a petition seeking cancellation of bail of a junior court, it can be filed under 439(2), read with 482. But revision may not be applicable.
I'll check it out, Lordship.
You kindly check it out. I'm almost sure, but you just check it out. Okay. But this is, now we are not even on that, right?
Lordship, yes, in the
Delay of-
condonation, yes. Notice may be issued, Lordship.
The applicant petitioner is seeking to file a criminal revision against an order dated 12/2/26 passed, order dated 14/8/2025 passed by the learned special judge NDPS Aizol in BA 142 of 25, granting bail to the two respondents herein.
Possibly, yes.
Right? Full stop. However, there is a delay of 92 days in the preferring the criminal revision, and therefore a delay condonation petition under Section 5 of the Limitation Act giving rise to this IA proceeding. Full stop. It remains. I'll make an observation. Just make an observation.
May not be required, Lordship. I'll check.
You check it up. I'm almost sure actually. Your revision don't lie actually. So actually, you may have to change your.
Before the other bench, and they say that the revision may be appropriate.
I may be wrong also. We can always be wrong. We can always be wrong because
I used to amend.
It is an interlocutory order actually. Bail is an interlocutory order, and specifically revision is not. The revision does not lie against interlocutory orders. So you can check it out. You can check it out. I will also check it out. So in that case, you may have to withdraw and file a fresh.
No problem.
As I said, the best, if the complainant has more locus standi, the best is to file a bail cancellation read with 482. That's the best. So what do we say today? Nothing.
Nothing.
Heard, learned counsel. We've already written that much.
Already written, yes.
So this observation is not necessary.
Notice may be issued to the.
Notice has been issued already?
No, this is the first time.
Oh, it's the first time. then I think you look up the position. Otherwise,
Sure,
it will waste your effort. You look up the position. If necessary, you change the track,
Yes,
and
yes,
then
yes.
then the you must notice. This is the matter after
3 weeks, Your Lordship.
as you wish. 3 weeks.
Lordship, notice may be issued, and in the meantime, I'll check it out.
No, because if you have to reframe your proceeding as a criminal petition, then you have to file again, take it back and file again.
Then 2 weeks, Your Lordship.
2 weeks. That is why I'm not. You look up the position.
Sure, sure.
And then it can be 1 week also if you want. I'm
2 weeks will be sufficient.
Agreeable. Look up the position. If you are convinced that no revision lies, then you withdraw, and then we'll issue notice.
Sure, sure.
Okay? 2 weeks. 2 weeks.
Part 2, item 1.